Beth Walker is a Deputy Attorney General for the Opinions Department at the Office of the Attorney General, Attorney General Leslie Rutledge. She joined that staff in 1985, and one of her expertise is drafting opinions. She's done that since 1987. The Freedom of Information Act is one of her areas of specialty, and today we look forward to hear Ms. Walker speak on a review of the Arkansas Freedom of Information Act. And with that, I will turn it over to Beth Walker. And if you need that, I'll give that to you.
Can you all hear me okay? I think with the group, I'm not sure I need that.
That's for your PowerPoint there.
Gotcha.
That'll help
Sure.
us cycle through.
I'm happy to use it, though, if anybody would like me to. So thanks for that introduction. I'm head of the Opinions Department in the Attorney General's office, and I have been doing that for quite some time. You probably know that one of the things the Attorney General has to do by law is to give her official opinion to state officials. And FOIA comes into play in terms of AG opinions in only one really discrete area by state law, and that's these employee types of records called personnel records and evaluation records, if you've ever wanted to get access to those kinds of records. One of the staff attorneys in my department will be here shortly, Ray Pierce. He's going to speak for a few minutes on those AG opinions with respect to those kinds of records. And here is Ray as we speak. And so I'm just starting, Ray, and I'm just introduced you, and in about 30 minutes, Ray will talk to you about AG opinions, those kinds of records, which you probably know is an exemption under FOIA. So I'm just going to do a general overview of the law, and in my 30 minutes with you, it's going to be kind of I don't want to say a dumbed down version, but if you've dealt with FOIA at all, either making requests, which I think is probably folks in this group are mostly going to be in a position of wanting access to records or meetings, right? I speak to all sorts of groups. Ray and I speak to officials who are in a position of enforcing FOIA and complying with FOIA, as well as members of the press and public who want access. So we've spoken to all sectors, about the law. So over the years, we've sort of developed this PowerPoint as a kind of a simple, I call this simple as. The law is not a simple law. It just isn't. And I've dealt with it for 25 years plus. And as an attorney, I can tell you, probably weekly, there are questions that come up that Ray and I are scratching our heads going, man, this is a new question. I cannot believe I've been at this for decades, and here's a new one. But it's a pretty lengthy law. You have a handbook here. Hopefully you've seen this before. It's in its 19th edition, I believe. The Press Association, you probably know, publishes this. Ray spearheads, he gets all the credit for the edits that go after every legislative session. We get it updated, okay? But the first part of this, if you've never noticed, is the actual text of the law, okay? So if you really live and breathe by FOIA, this is a good thing to keep in your hip pocket because it has the actual language. And you'll see it's lengthy. It's not a short law. And unusually for state laws that our legislature enacts, there's actually an intent statement in FOIA, in our FOIA law, which, as I say, is unusual for state laws, okay, where the legislature actually wrote, this is what we intend by this law. And this concept of transparency and the act to be construed in favor of openness, that is, public access to what we call non-exempt public records, and I'll explain that a little bit more in a few minutes, and then non-exempt public meetings, the act is to be construed in favor of openness for the public, and exemptions, which is some of what Ray's going to be talking about, are to be narrowly construed. And that kind of comes from Arkansas Supreme Court case law, but it really starts from the language of the act, which, as I say, is unusual for the legislature to actually tell us what they intended by this law instead of us having to sort of divine what they intended by the written word, which is what I've done for 30 years, is try to interpret statutes. That's basically my law in authoring opinions for the Attorney General's review and approval. So let's get into the simple, and I cannot overstate that it's not a simple law, but we've tried to simplify it, these 3 steps. Seems maybe kind of silly, but we came up with this years ago because we really think people get ahead of themselves in dealing with FOIA, okay? So the first step is the entity you're dealing with, a covered entity. For the most part, when Ray and I talk on FOIA, about FOIA to different groups, we're assuming it's a governmental entity that's subject to FOIA. Private entities, you probably know, there are records that private entities have. There are theoretically, not much case law on this, meetings that private entities would have. So private entities in some circumstances, we think, can in some respects be subject to FOIA. I don't really have time to go into that, but just so you know, it takes direct public funding plus something more to get access to records that are being held by a private entity. There are some procedural questions about how you go about getting records that are being held by a private entity. And if anybody got questions about that, that could be like another 20 minutes probably by itself. So most of the time this morning, we're going to be talking about entities like county government, city government, state agencies like that, where there's really no question that, if they have the records, and if the records are, no exemption applies, they're supposed to be providing the records to a citizen who makes that request. So we're assuming step 1 here is met for the most of our talk. Step 2, very important, you don't get to step 3 until you've gone past step 2. Is the record I want, does it meet the definition of a public record, which we'll get at here momentarily? Is the meeting I want a covered meeting by FOIA? Does it meet the definition of a meeting under FOIA? If so, then you go to step 3. Okay, fine, but does an exemption apply? Might the record be exempt from public disclosure? Might the meeting still be closed to the public? Don't get ahead of yourself. We find out with agencies particularly, they're going to the exemptions and they haven't first decided. And we don't want you, anybody on the side of making a FOIA request, to be frustrated and thinking that because you've made a request for a public record that you just are going to get access. An exemption might come into play. So let's flesh this out. Excuse me, that was quick. Woo, that thing's touchy. I'm sorry. What is a public record? Here's a definition. It's a big, long definition under the Act, okay? Unlike meetings, which I'll get to momentarily, the records definition is pretty lengthy. And it's pretty helpful. There are still questions that come up. We've tried to break it down into the elements of what is a public record. Now again, remember, just because they call it a public record doesn't necessarily mean it's open to the public. We're still in step 2 here. An exemption might still apply. But what we're wanting, we have to make sure still, as a threshold matter, meets this definition of a public record. So really, how it's kept, which FOIA talks about, that's the medium, whether it's a written piece of paper, whether it's an electronic record, audio, video. That's medium is the technical term under FOIA. Doesn't matter how that record's kept, okay? It can meet this definition regardless of how it's kept. It does have to be kept. We have questions, as you can imagine, particularly in today's day and age with electronic communication devices, when is an email still kept? When is a text message still kept? Questions come up about that. Remember, I've got 30 minutes here, so I'm trying to keep this simple and throw out to you some of the issues that come up in what's a record. It has to be kept. And I mentioned that very important is when you're making a request, make sure you're asking for information as contained in records that you have. Because there's no obligation, you may get this thrown back at you. Custodians, and that's a technical term under FOIA, for the person who's responsible for handling records and requests and providing non-exempt public records, they don't have to create a record to respond to your FOIA request. FOIA is really not about question and answers, expecting somebody in the public sphere, governmental employee or official, to answer a question. Now, if they're a good public servant and they know they answer the question and they're confident, they should probably answer it. But it's not a FOIA request. FOIA is about making a request, and obviously you're seeking information. It's the Freedom of Information Act. But it is seeking information through existing non-exempt public records. So the record has to be kept. It has to be something that's kept. And then, very importantly, this third step has to reflect, constitute, be a record of the performance or lack of performance of official functions. And I hit on this really hard when in our longer 2-hour presentation. By that time, you're probably kind of, going blind when Ray and I speak for 2 hours. But I spend a lot of time on this third element of what's a public record, because particularly when you're dealing with, we see a lot of government officials coming to us frustrated by somebody wanting, I want all the emails of all your city council members for the past 5 years, on any device, whether it's public or private. And it's true, the device they're using doesn't matter. We don't think that matters. If you're, conducting public business on a personal device, potentially those records on your, we tell public officials all the time we're speaking to, potentially, that you think that's a private device and that should be a private email, but if you're using that to conduct city or county or state business, it's potentially going to, if the record's still there, on that device, if it's still kept, if it reflects the performance or lack of performance, it's going to be a public record. But what does this make the custodian have to do? And this is what I try to emphasize too, for these voluminous requests. They've got to go through each record. We know that from case law. They can't just say, well, you use this device to, we know you use this device to conduct business, so we just get all your email. It's a content-based, record-by-record test. And I know that was very frustrating to the plaintiffs in this Pulaski County case years ago, and it went up and back on appeal, finally to the Arkansas Supreme Court, and the court said no, that judge was supposed to look at each of those 600 plus emails and decide which one reflect the performance or lack of performance of official functions. So it's not a context-based test. It's not just because it was a public official and we know she was using her public, her private or public device, and there's email, and that she's doing business on that device. You got to look at each one. So I mentioned that to bear that in mind when you're making your FOIA request, to keep that in mind and make your request as succinct and narrow as you can. I mentioned emails and texts because it's a big deal. That's the sort of the forefront. A lot of states have amended their FOIAs already to update their laws to deal with these kind of electronic communications. We have not. And the last time our act was amended to deal with electronic records was in 2001. And they were great amendments, but they were even still behind the times when the Electronic Records Study Commission was put into place and studied how do we update our FOIA to deal with electronic, computerized records. Now it's way past time to deal with these records. And as a consequence, both on the requesting end and the public body end who's handling the records requests, a lot of questions come up. And there's a case percolating its way up, I think it's still on appeal, dealing with emails and when public and private communications are sort of commingled, when's it going to meet the test? Because remember the definition? It has to be a record that constitutes, it has to reflect the performance or lack of performance of official functions. So we've got a few instances where public employees, there's some business going on, maybe with somebody in the private sector that the public's really interested in knowing, was that contract, did that person properly get that public contract paid for with public funds? Was some undue influence come to bear? And then maybe they have a personal relationship involved, and we get these, as I say, commingled public-private, very fact-specific. You look at each email, and at some point a judge is just going to make the call, and it's going to go up an appeal on that record. That's the way cases get resolved. And all we lawyers can do is tell you what we think, what the court has said, what the legal test is for when an email or a text message is going to meet this definition of a public record. And there has to be a substantial nexus between the business activities and that email, reflecting a substantial public business. So once we decide it's a public record, here's the rule. It's got to be disclosed. I mean, the custodian has to disclose it unless some exemption applies. Exemptions can come into play either by state law, by federal law, but for the most part, once the determination is made that it's a public record, the custodian should be in the posture of, not searching for exemptions. I try to informally counsel people, because we spend a lot of part of our time, believe me, taking phone calls on FOIA where the Attorney General cannot engage in the private practice of law. So it's kind of a fine line. We can't counsel people individually as lawyers. Sometimes that upsets people. Well, you're the public's lawyer and she's the chief lawyer for the state. You're my lawyer. Well, we're the lawyer for the public generally, but not for people individually, if that makes sense. So she can get in trouble if she actually tried to counsel you as your lawyer. So Ray and I are really aware of that, and we try to speak generally about FOIA. We try to point people in the right direction. If we've done a previous AG's opinion on it, we try to get people there. I sometimes probably cross that line a little bit of trying to say, well, but I'm trying to make it clear, this is Beth Walker talking. I've dealt with FOIA a long time. I'm just saying, I wouldn't want to stand in front of a circuit judge and make that argument, city attorney, that you're trying to make. I have those conversations a lot. Now, whether it makes those records be turned over or that meeting open, I don't know. But I'm very aware that once you're comfortable it's a public record and I hear people trying to pigeonhole something into an exemption, that's not a good place for that lawyer who's count to be, okay? The exemption, because once again, let's go back. Exemptions are narrowly construed. The act is interpreted in favor of openness and exemptions are narrowly construed. So the exemption needs to be pretty darn clear to prevent that public record going out once it's determined it's a public record. But again, that's a record by record inquiry, okay? And sometimes there are lots of surrounding facts you have to take into account, even beyond just the face of that written record. So now, I've got a few minutes more here to talk to you about some of the mechanics about making a FOIA request. If you've done this before, you know it, you probably know the drill, but I thought it probably couldn't hurt to just mention, because I know we hear sometimes people calling in and say, wow, I was making a request to X, Y, and Z, maybe a police department somewhere, maybe a city clerk, and he or she was like, well, put that in writing. Do FOIA requests have to be in writing? No, absolutely not. And I don't think you even have to use the term FOIA when you're making a FOIA request. I think it's a good thing to do, so you're on the same page. But now we're at the point of, we want a meeting of the minds between whoever you've presented your FOIA request to, okay, and you. You want that person to know, which is the custodian. That's the person that the agency, the city, government, body has told that department at the city or at the county or that state agency who's in charge of our FOIA request. And we've done that in the AG's office, because obviously we get FOIA requests. And we've designated, it's our chief deputy, Julie Benefield, and she is our official records custodian for the office. So Ray and I and my team assist in responding to FOIA requests to the AG's office as well. But everything goes through Julie. We have and every body should do that out there. When we speak to government officials, we say, it's not courage, it's really required by the act. The act contemplates that you don't bounce people around. Well, I don't know who'd have that record here. We're a big agency, let me check. No, they're supposed to have done that at the front end, designated someone for you to go to immediately, who has administrative control of the records. And how you make the request, if they reasonably know you're looking for records, doesn't matter, fax, in writing, email, it doesn't matter, phone call. Here's the specificity part, and this is what I was mentioning about having a meeting in the minds. And this is, I put quotations here because records requests are supposed to be sufficiently specific to enable the custodian to locate them with reasonable effort. That's in the language of the act itself. And that oftentimes gives a custodian a basis to say, I just don't don't know what you're looking for. And frankly, we see fishing expeditions where somebody really doesn't know what they want. And we do see situations where people are just upset and they're submitting the same FOIA request to the same police department day in, day out, and they want like 10 years of records, and they're really just, it really is kind of a harassing thing. We see that, I have to be frank, we see it. We see the other side too, of agencies not sufficiently processing requests, maybe hiding a little bit behind this with reasonable effort, but you just got to know that's in the act itself. And why is that? Well, it's because the FOIA Act, the act says that records are to be made available immediately unless they're in active use or storage. And then it's what you probably know is called the 3 working day rule. We think for the most part, public records are in active use or storage. That's never been fleshed out in case law. But anybody asks me, I think we're beyond the point of a whole lot of serious debate about thinking that you should be able to walk into a public office and say, I want all your records for this period of time and I want them immediately. I mean, I just don't think any circuit judge, if you tried to go to court and they said, no, we're going to make our best effort in 3 working days. We know that's the time frame under the act. I wouldn't jump and go to court over that right away. I think for the most part, it's 3 working days. But it's with reasonable effort. And so reasonable effort, given that 3-day time frame, just bear that in mind when you're making your request. Try to really narrow it down as much as you can to capture the records that you think might most logically contain the information you're looking for, okay? And then medium and format, that's getting into a little bit more of the weeds and the detail than you need to know. But that's like changing from PDF into PDF from a different format and like that. So the big takeaway here is, doesn't matter how you make your request, make it as specific as you possibly can, so you don't get this response of, well, that's just too broad. I don't know what you're looking for. Once the custodian knows what you're looking for, they're supposed to provide the records. And you probably hear about, and maybe you've been in a situation where the records you really want, there really are 5,000 records. I mean, there really are. But remember, let's go back to the definition of what's a public record. That custodian is supposed to go through each one of those records. And this is the part of the act that, to me, we've tried. If you follow the legislative sessions, the last couple ones on FOIA and the bills that have been proposed, there have been proposed bills to try to handle the very voluminous records requests. Because there's no question, those are legitimate records requests. Once the custodian knows what you want, and there are a ton of emails that are responsive to her request, and the custodian's got to process that. There are no exemptions, but we've got to go through. We predict that there are going to be 3,000 emails. Can that be done within 3 working days? If you're dealing with, a water department at a city that has 3 employees, it might shut down their department for 2 weeks. Probably no circuit judge is going to give you relief there if they say, look, we're going to do what we can in 3 working days, but we really think it's going to take about 2 or 3 weeks, and we're going to. So what we've suggested is come to an agreement. Is that really under the act? No. Some of this is just about being civil, and on the public side, letting the person know that you know what they want, you know they're entitled to it, you just can't process their request within the required time frame. So what did I do there? I did. I got off it entirely. As I say, I'm really old. I think I'm probably done too, aren't I? Ray, when are you supposed to start?
Yeah, about another 10 minutes.
Okay, good. Okay. So questions about records? Okay. Yeah. Yes, Mr. Lewis.
One of the things on custodian of records, Beth, I always try to do.
Can you use the microphone, please?
I never rely on let's say if I'm talking about the city records, I never rely on who they tell me is their FOIA person. I take it literally, George, that I'm going to go directly to the mayor if he's the one who's administratively in control. I'm going to make my request to him. Now, if he wants to have someone else you know, find the information or whatever, that's fine. But I'm going to hold him responsible for his answer. Comment on that, if you will.
Well, I think that's a sort of a practical consideration that may depend on the city, you're dealing with, and just how quickly do you want a response? Because the mayor obviously is not going to be the one processing that request. Ultimately, if you get in a dispute, I would hope the mayor would be available to be involved. But the act does contemplate that you submit your request to the custodian, who is the one with administrative control of the records. It doesn't say anything beyond that. So that the act allows that city to designate a custodian, and it may not be the mayor. So, I think that's fine as a practical matter, and maybe that's working for you. If you're dealing with a really big city, I probably wouldn't suggest that. I think that might get your request bogged down a little bit, but what the mayor's office should do is immediately shift it to the custodian.
Colonel Parsons?
Yes, I'm sorry.
Jim Parsons,
Yes, sir.
Benton County chapter of TIG. I went through my state representative about a month ago asking for an opinion from the Attorney General, and she told me it'll probably take 2 or 3 months. Is that true?
Well, now we're outside of the context of FOIA, and we're talking about under a separate law, the Attorney General is required to give her an opinion on state law to state officials. The time frame varies dramatically in terms of when those opinions go out, because the statute doesn't set unlike the FOIA, when we're dealing with those public employee records, those opinions have to go out within 3 working days, and Ray's going to talk about that. So other AG opinions that the governor can seek, and in your case, you happen to go to a state legislator who's obviously a state official, prosecuting attorneys, we get AG requests from them, from all the other constitutional officers, Secretary of State. I would like to say a 30-day turnaround would be marvelous. It's just not practical in today's day and age, given the volume of requests that we get and the review process they go through. Because, as you may know, AG opinions are not binding. They're not the law. What my department does is we're trying to best predict if a court gets this question, what are they likely to rule on this question? There has to be a state law question. And they're not binding on anybody, but we hope that we take them seriously enough and we research them diligently enough. And my husband's in private practice, and he gets very frustrated on a regular basis how long I research state law issues. He's a litigator. He has like 30 minutes to decide questions. Okay, I got to decide if I'm going to file this motion to dismiss or not. I'm like, well, no, I've been working on that for 3 days. And he's like, because, he can't bill for it, okay? You're paying my salary to get to the best answer for the state's chief lawyer that we can get for you. And they're published, and people do rely upon them, even though they're not binding and they're not the law. So it is a lengthy time period. And right now, I don't think 2 months to 3 months right now is not out of the ordinary. I mean, I would love to have them be quicker. But if you knew our process and you knew the number that we get and the significance of the questions, and just so you know too, other states, Arkansas is among the very few states that issues hundreds of AG opinions a year. Many, many states issue like 30. And they're only on the biggest constitutional questions that came down for the state, like the Lakeview School District case, when there were big-time school funding issues. So I'm making the case, I guess, for why it takes so long to get an Arkansas AG opinion, because I can understand from people's perspective that seems like a really long time, but that just kind of is, where we are right now. Yeah. I mean, it's really the levels of review but even our drafting process is lengthy. Sure.
Let me ask you a question about access to the Attorney General's office from the public standpoint. I understand sometimes that maybe a city councilor may know, hey, I think I can go maybe get some advice or have a conversation with Beth Walker. How does the public, John Q. public, how do they know, or what can they do with regard to contacting you if they have a question regarding some of these issues, some of the FOIA issues we're talking about today?
So we have a constituent services department that those kind of questions we have on the AG website, a lot of FOIA-related questions from the public Arkansas citizens come through our website. That goes to a department called our Constituent Services Department. Then if it's a FOIA-related question, everybody knows to reach out to opinions. And that question will get to my department. And the best we can do in most instances, because we cannot engage in the private practice of law, we can't counsel people, but we can look to see, is there a previous AG opinion that's addressed that before? Okay. You know, oftentimes those kinds of questions, though, they're in the heat of battle. I mean, they're battling to try to get records that they've been unsuccessful getting, and they're back and forth, and they want the AG to step in. And that's where we have to frustratingly tell people the AG is not a compliance office. She does not have powers to enforce FOIA. That's the prosecuting attorney. Or you go to court yourself. You can file what's called a pro se lawsuit, FOIA suit in court. That's just the way our law is set up. Some state AGs do enforce FOIA. Now, I will say the ones that do have tens and tens of lawyers. Like, you know, some states have 50 and 75. That's all they do. They have a FOIA department. You know, we're not set up for that, mainly because the AG's role under FOIA, frankly, is pretty limited. So Winston Bryant, I will tell you, actually, I was hired by Steve Clark, started this process of going out and speaking on FOIA, okay? And every AG has continued it. We used to go to all the congressional districts. And, you know, Mr. Lewis knows, we used to come up. Now, with the advent, we don't travel those distances like we used to. But, so we inform people, we try to educate people, but we don't enforce FOIA. So it's kind of that fine line we're riding. She can't counsel people individually, but we want to be helpful because we know for everyone, knowledge is key. And ignorance of this law is not a good thing for anyone. I mean, it's just not a good place to be as a public official in particular. Yes, sir.
Yes, I have a question. I'm Dr. Steve Montoya, and of course it's about health. And so if I was worried about the health of the governor of the state of Arkansas, could I write a FOIA request for his medical records?
Well, you can always write a FOIA request on that one if the records you're seeking meet the definition of what's called a medical record under FOIA. Then that would be an exemption. So remember, we talked about those 3 steps. Governor's office, obviously that's a public entity, so it's very appropriate to submit a FOIA request to the governor's office. That record may or may not meet the definition of a public record. I don't know if we've ever had that before. The governor's, I don't know, I might make the case that knowing his state of health is really critical to the Arkansas citizens. We're entitled to know his state of health. So you might be able to make the
health care that he received while he was governor.
Right. So that might meet the definition of a public record, but you're in that 3rd step. Does an exemption apply? And I think probably based on privacy considerations, but among the, how many are there now, Ray? 28 exemptions under FOIA. Medical records of public officials and public employees are specifically exempt. So you would not get his medical records because they're exempt under the Act. And that's a good example. I'm glad
Under the State Act.
Under the State Act. And the federal law does not apply to the governor's office.
Now, what if I wrote to the office of the President of the United States and I wanted his health record?
I really don't know. I'm not an authority on the Federal Privacy Act or the Federal Freedom of Information Act. My guess is there's a similar exemption, and you would not get that as a member of the public. Okay. And that's, again, by virtue of laws that our legislature, in the case of that, would be Congress, in the case of Arkansas, the Arkansas General Assembly. And that medical records exemption, I believe, Ray backed me up here, I don't know if you know, the law was passed in 1967. And so I think the medical records exemption has been in there since 1967. So it's a long-standing exemption.
Could I bypass that and go to his private position, the president's private position, to get his medical records?
No, and that's the reason why is that's a private entity that's not going to be subject to FOIA. Its records of a private physician are never going to be subject to FOIA.
Could I bypass that and go to the hospital where he was taken care of?
No, those records would probably be exempt under HIPAA, which is federal law.
Could I exempt that and go to the Supreme Court?
Well, you can always get to the Supreme Court, but they'd have to ignore HIPAA, which the U.S. Supreme Court would not ignore HIPAA. That's a congressional law.
I need the researchers for it.
Yeah, okay. So I think I'm finished with my time. I did want to just mention about rec meetings.
Let's
Oh.
give a little bit of an extension here.
Okay,
if we
sure,
can. Can we answer a question?
Oh, yeah.
Mutu has a question, and then.
And we're
then
happy to go long. We want to stick with your schedule, but we're happy to, whatever y'all want to do. We're open, we're free.
Okay, well, let's answer this question, but I would like for you to
Talk about meetings a little bit?
open
Okay,
meetings.
sure.
So, Mavuto Kalulu from UCA,
Okay.
Atchison Center for Research in Economics. Are there records on the number of requests that each agency receives, and even at county level? Because from a requester's side, when you give an excuse that we don't have resources to satisfy the request, it looks like we are based on the information that is coming from the other side, but we don't know the number of requests that each agency receives each year or over a period of time. Is there that record?
I think I understand the question. So he's asking, are there any, is there a way to find out how many FOIA requests some state agency, I don't know particular, but this would apply at the city or the county level as well, because I take your questions reflecting some concern that you're being told, well, we just don't have the resources we get so many FOIA requests that, now having, so I think the quick answer to your question is I am not aware of any state law that requires public entities to keep a record of the number of FOIA requests that they get. So I don't think I can point you to a law. I don't think you're going to find a law that mandates that. The question is, but some of them might do it. They might have that record. So I would suggest you make that FOIA request. But remember what I said about what's the definition of a public record? It has to be something that is already kept. If they don't have a record of the number of FOIA requests they receive, and if they're not required to keep such a record, which I don't think they are, then the answer probably ultimately you're going to come up empty-handed. And I know that's undoubtedly frustrating, but I will go back to your statement, though, that they say that they don't have enough resources. That is not an appropriate response to a proper FOIA request. If you're asking for records and they know what you want, it's a sufficiently specific request and the records exist. They should not be telling you, we don't have the resources. The law requires that they have the resources, okay? Your tax dollars are paying for public entities to staff up to handle FOIA requests. Now, if you're asking for information and you want them to gather information for you and create a record, they don't have to do that. And so I would make sure you're communicating, and you're getting, now are you telling me that you don't have records of this? That's your response back to them. And they don't have to create a record that doesn't exist. So they probably don't have to create a record of the number of records that they've gotten. Does that make sense?
Yeah, it does make sense, but I'm asking from a researcher point of view that it's better to make those decisions based on the data. So if there's an entity that was keeping track of those requests, it will help in advising how best to go with
I think as a practical matter and as a policy matter, we have that capability in my office because we track all our FOIA requests to make sure we're handling them timely. And so, in our office, we might be able to provide that record. We've never had anybody ask us, but we might be able to do that. So very quickly on meetings, so the FOIA deals with two separate, discrete areas, records and meetings. Same rules, some of the same rules apply to meetings, and that is the entity covered, is the meeting covered, does an exemption apply? So we're going to go back here to what's a public meeting. and Ray oftentimes speaks on this. I'm going to go through it really quickly. He does a great job. But it's frustrating to us that the definition of the term includes the term. As lawyers, to define a meeting as something that's a meeting is just not very good draftsmanship. But remember, this has been in here since 1967. So, you know, this is where we are. But we do know it has to be a governing body. So if the sheriff gets together with the prosecuting attorney, gets together with a city attorney, gets together, I mean, that's, and has a meeting, they meet, it's probably not going to be a public meeting for purposes of FOIA because those three people are not a governing body, okay? Now, when the governor and the secretary of state and the attorney general get together as to redistrict, the Constitution requires that those three individuals do that. So for that purpose, they are a governing body, okay? So it has to be a governing body. We don't have, unlike some laws, do not define a meeting in Arkansas with regard to any particular number in attendance. So I'm very, very careful when I'm speaking to members of a city council, members of a quorum court. Whenever the two of you get together, if you're talking public business, particularly if it's something foreseeable to come before the city council, the whole council, or the quorum court, you should stop right there, okay? Because it's quite possible that would be a meeting. What we do know is sort of sequential meetings is a real problem. The straw man, we've got case law on that coming out of the city of Fort Smith, a number of cases, where you're not going to get around 2 or 3 members being in a meeting by saying, well, it was the city manager meeting with the member of the city council one at a time. Okay, the court in this one case said, no, that's a meeting. You can't avoid the act by those kind of shenanigans, if you will. But the general rule is you're going to have at least 2, and then it's going to be oftentimes a factual question of, was it really public business they were discussing? How foreseeable was it that it was going to come before that whole governing body? You probably should know now, they got to audio record it and keep that for a year. This is very, very new, well, new to us, it's session before last. You can attend meetings, no right to participate. You probably know there's a public comment period oftentimes, which is, I think it's a great idea for governing bodies to do that. They're not required. If they want you to sit there and observe the meeting and not let you comment or participate at all, they're entitled to do that. And they can vary from their agenda. There's no agenda requirement. But what do? They do, oh gosh, I'm so sorry, y'all. They do have to give you public notice. And you probably know about the notice provisions of FOIA. Ray will do a better job of this, I promise. There's your notice requirement. 2 hours for those emergency special meetings, but that only goes to the press. It's just the way the law works. Regular meetings, anybody who asks for it. Bottom line, if you want notice of a public meeting, you got to ask for it. Don't get upset if you find out later a public meeting was held and you didn't know about it if you didn't request notice. You have to ask for notice. I threw this in here because we knew this was the law before COVID, but now the whole idea of holding virtual meetings, there's case law we think that probably blesses that, but they've got to do it properly so that you can listen in. You don't have a right to participate, but you have a right to be listening in, and that's where that video came in too. Because we have the exemption, I mentioned about records, I just wanted to mention briefly, this is what Ray's going to be talking about, and records side. Once you've decided something is a public meeting, which again, it's the governing body getting together, doesn't matter the number, there have to be enough there to make it a meeting. That can sometimes be factually a question mark. But once you've established that you've got the governing body there and it's a meeting, you can pretty much safe to assume that's got to be held as a public meeting. There are very few exceptions to the open meeting requirement under FOIA. If all you take away today is, on the public record side, there are a number of exemptions. You may not get that medical record you wanted, okay? You may not get that employee record you wanted, which is Ray's going to talk about, okay? But if it's a public meeting, meets that definition because it's a governing body getting together to discuss public business, it's probably got to be opened. This is one of the very few exceptions. There are like 3 or 4 now, and some of them are like, came out of like post 9/11 water security and some sort of arcane ones now that I don't even think come up very often. But this business of considering hiring, firing, appointing, promoting, demoting, disciplining, or the resignation of a public employee, that is the one that sometimes they can hold a closed meeting to deal with those particular matters. But that's basically the only time. Once you know it's the governing body meeting, they should be giving notice and holding it as an open meeting. If it's a closed meeting, they've still got to do these things. And most importantly, they've got to vote in public afterwards. So if you think that, sometimes what they'll do is they'll give you notice, we're going to meet, and then they're going to go into a private executive session, it's called, which closed, secret, whatever. And let's say it's legitimate. It's for one of these proper purposes to consider one of these things with respect to an individual. They can't be talking about personnel policies generally or salary generally for their employees. It's got to be specific to the individual. And it's usually a matter of discipline, Are we going to take some disciplinary action? They still got to do this stuff, okay? Who can attend? And by the way, we have the more robust of this website, PowerPoint is on our website with all of this fleshed out in a little bit more detail. And I'm past my time. Sorry, Ray, I cut into you. If they let you go over a little bit, maybe, I don't.
We've got a break, so we're going to cancel.
We don't want to mess up your agenda too much. But it wasn't on me. I took those questions, right? So don't blame me, Ray. So thank y'all. And these are just your sources, okay? That third one, if you're just really geek like we are, make sure to get that. It's very detailed. I guess.
Yes, thank you so much. That was really, really informative. We appreciate that. Sorry we didn't have time to explore more, but we'll be having more of these meetings. But that is really helpful. I think knowing that the public knowing that they can go to a website and pull up your PowerPoint, I think that's really helpful. And know that they have access to you in some form or fashion is also helpful. I think you touched on some of the laws. One of the relatively new ones is recording of the public meeting. How long do they have to? Not only do they have to record it, they have to keep the copy of the record. Is that correct?
Right, for a year, I believe.
Will you speak in the, if you have that mic there?
That's for 1 year. We're supposed to keep that video recording, audio. It doesn't have to be a video, right, Ray? I know you.
It doesn't have to be video.
It doesn't have to be video, but it has to be audio. And they must keep it for at least a year.
And if they don't, that's a violation of the act.
I would think so.
Yes, and when, for example, when there's an executive session to consider a resignation or a disciplinary matter, notice still has to be given to the media.
That's correct. And oftentimes, if that executive closed session is not planned in conjunction with a regular meeting, sometimes that is the only notice, right? That 2-hour notice, which I've always thought was curious, but I think the idea is the press is going to perhaps be the most interested in that question and presumably report back to the public on what came out of that executive session, if anything. But if there's a public portion of that meeting, I believe they should be doing an audio recording of that. Is that where you're headed?
Yes.
Yeah, I think so. If there's any, the public portion of that, and then they go into, I guess it would retire into, or whatever term they use, to go into their executive session.